All right, welcome back, everybody. Here with Jeff Kahane.
Thanks for having me,
Jeff.
Thanks for being here.
It's always so good to have you on
me.
the show, and everything that you've done for us and sharing your knowledge. Having Jeff come in and teach your classes were always sold out. We're absolutely thrilled, and you've come on again to share more information for us. So first of all, been a little while since you've been on the show. Welcome.
What a great transition that they've done in here. It's like magic. It's like I feel like I'm on NBC News or something.
Perfect.
Yeah,
It's the same thing.
Yeah,
Same viewership, give or take a few million.
Commercial costs are the same amount of money if anyone's looking to take out an ad.
Yes, exactly.
Excellent.
Well, so Jeff, take us through a few things. The thing I love about coming on is we have no questions pre-prepared for Jeff. Jeff is just a walking encyclopedia of real estate knowledge, and you've participated in assisted area, and you actually just won an award this year through CREB.
Yes.
And it's
so well deserved.
Yeah.
I had goosebumps.
It was me too. It was the first time in CREB's 90-year history that a non-real estate agent was recognized for CREB, for contributing to CREB.
Yes.
And I mean, I love our industry. I love the people. I love
Yes.
the clients, and every step we have, we can make things better. Like, fantastic. I love it.
Yeah, and you've been a public advisor on various boards. You've done so much. So thank you.
Thank you.
Thank you for everything you've done. Okay, to the matter at hand.
Restrictive covenants.
Restrictive covenants. Take us through and maybe start from the top.
Like, what is a restrictive covenant?
Why are we? Yeah, well, no, it's actually a great question.
I'm going to start that way.
Let's
I think
start
that's
that
a good
way.
way to start.
Yeah, go ahead.
I'm going to assume
then
that
all
everyone.
three of us will know what it is.
That's right. Everyone. So, restrictive covenant. It's a registration on title, and it will be clear because it'll say restrictive covenant on the little descriptor tab.
Sorry, review that again.
Yeah,
on
go
title,
back. On title, it'll say restrictive covenant.
I-
Although sometimes it'll say caveat, RE, restrictive covenant. Yeah, so it's like really confusing. Sometimes it's just by itself restrictive covenant. Sometimes it'll say caveat, RE, restrictive covenant. So either way, they're both enforceable against the property, and they tie into the property, and it's a restriction on what you can do with the property. Why is this important?
Tell me, why?
Oh, yes.
Why?
Who's there?
They didn't have a list of
Wow.
questions. I'm making them up as we go along.
That's right.
So they're important for buyers and sellers because it can tank an entire transaction, which is fairly serious if you want good things for your client and commissions and all those good things. But it also restricts what a buyer can do with the property. So we'll go through sort of the bigger examples in a second, but these are things like you can't put an asphalt roof on a property, or the fence has to be chain link. So if you see a property, your client sees a property and they love it, it's so good, they just want a little more privacy because there's a golf course.
Yes.
There may be a restriction on what they can do with the fence. And they really, some of them even restrict the color of the property. There's some significant things that are in there.
Yeah. The fence is that's very restrictive.
Have you own an animal of some type?
All kinds of stuff.
Yeah.
Yeah. So for your buyer, it's so important for them to understand, what am I actually getting? And if people have seen my course, I like this analogy because, former grade 4 teacher, I like analogies. If you're doing a showing or showing your client a home and you're taking them through, the first time buyer, 50th time buyer, doesn't matter. You take them through, here's the master bedroom, look how beautiful it is. Here's the dining room, here's the basement, there's the kitchen, but don't look at the kitchen, okay? You're gonna have to put in your offer before you see the kitchen. It's really no different because the restrictions can be significant, and I'll get into some examples that are really significant, and your buyer needs to know about it. They need to know what it is that they're getting. So that's why they're important.
So you talk about that, but most people, or I shouldn't say most people, many people, because it's not most at all, didn't think you need to pull title with a buyer. So my question is, do you need to pull?
What?
Yeah, isn't that crazy?
Don't be that person.
Don't be that person. We mandated, and that obviously you need to pull title with the buyer as a required document. But people are like, well, why do I need to do that? And they're like, oh, they've written the offer, and then it's like, okay, now I'll go and pull title.
Right. And if they've reluctantly gone that far, often they'll say, well, the lawyer's going to see it anyway, so that's fine. But here's the thing. By the time people come to us, conditions are waived, the contract's firm, like they're buying that home with whatever the restriction is. We can tell them all day long, but it doesn't give them the opportunity to back out. And 100% of the time, that's when a client says, if I had known I would not have bought this house, who's responsible for telling me? Like, really your client needs to know what it is that they're buying before they agree to sign the contract. So important.
Totally.
Yeah.
So we won't even
Before they sign the contract. I mean,
Before.
you don't need to, when you're showing 15 houses, you don't need to pull title and everything.
No,
else
no,
you're
no,
showing.
no.
But when they show interest, and
Yeah.
it's like, let's start doing our due diligence on this,
Yeah. Pull it.
title is part of it.
Yeah, no, they need to know that there are utility right-of-ways that are going to
100%.
keep them from building that beautiful gazebo that they want to sit under and look at the mountains through the rain. And, had I known I couldn't build a gazebo that spot because utilities or overland water drainage, I'm getting off topic because it's not restrictive covenants, but same idea.
Yeah.
It's restrictions on what you can do. They need to be aware of what they're buying on title.
Totally.
So can you tell us a really bad story about something that happened once?
Or even just give us some of the examples.
It's Halloween, a really scary story.
So we have lots of hauntings.
We should dim the lights and have like a little flashlights. Yeah.
We have a lot of hauntings and unnatural death stories, but not really related to. Oh yeah, we've dealt with like 6 or 7 of them over the last 20 years. Hauntings. Ooh, we should do a Halloween special.
So does that like somebody has disclosed that like the house is haunted?
Correct. Sometimes
They
in
must
advance.
really believe it to feel like
Yeah,
they need to
I've
disclose
had a seller.
Oh my gosh.
What's the language to properly disclose a benign spirit? All right, let's work on this.
So buyer and seller agree.
Yeah.
Benign spirit.
Yeah.
You know what's interesting though? If somebody said that, you would move in. I would not move in.
Yeah, I'd be there in a second.
Yeah.
but not until I negotiated the price way down.
Oh yeah, for
because
sure.
of said benign spirit,
Right.
happy spirit,
and I
like
burst
Casper,
and I
Well,
said,
but if they're going to
Or-
do your laundry and stuff,
like paranormal activity.
maybe
That's right.
maybe pay more.
That's right.
Yeah.
That's right.
Yeah.
Exactly.
Yeah, they didn't say that kind of benign.
wow, interesting.
So no kind of spooky kind of things like that, but some of them are super, like very significant.
Well, there's real implications.
Oh, for sure. And like we'll get into the reasons why people think, oh, it doesn't matter. 1911, it doesn't matter, it's expired. No, if it's on title, it's still enforceable. Oh, it lists some guy who's dead and it doesn't have the city. The city told me they don't care. The city never cares. It's an agreement between landowners, property owners, and everyone who has the same restrictive covenant is affected. So sometimes you have just 2 properties. So if we're going to make a change or deal with it, nice and easy, because as long as they both consent, it's easy. Usually, there's things that come up. But if you have like a whole community, like Oboya says, you can't put a garage within so many feet of the alley. If the garage is within so many feet of the alley, anyone in the neighborhood can make an application to the court to have it removed or moved. We have had people who have spent tens of thousands of dollars sandblasting their brick because they painted it black and they weren't allowed to paint it black.
Yes.
We just came up with an interesting one where it's like, I don't remember what church it is, some kind of Church of Zion. And if you do certain things like sell alcohol out of your property or, there's a bunch of things that are specific, but then there's a very general or any other immoral act.
Oh.
Yeah, so I don't know what that is. Your property reverts back to the church. So you have people, I'd have to look at it, I don't remember offhand. But in the city, in the city of Calgary. So there's a community and the church had the land, they subdivided the land, and they put this restrictive covenant on in 1940 or 50 or 30, whatever. And now, originally it was all people from the church who bought the land, but as time goes on, other people are buying it, and there's a restriction saying, and I mean, chances are you're not selling booze out of your house.
But you're probably doing some immoral acts.
I don't want to talk about what you guys, we heard about the role play earlier.
That's funny. Yeah, that's right.
But, and that standard probably would be very different between what the church believes is an immoral act and a person, but they have a legal right to take your property.
Well, and I think of things as as edibles just became legal, and it'll be 60 days before they do, and who knows what drugs will be next. And not saying that that would be considered an immoral act at all,
but it may.
And maybe the church deemed it as immoral, and now you just have to fight it, and you might win at the end of the day. But who wants to go through that? Oh my gosh! Exactly.
Yeah.
Yeah. So
and other ones, and they're easily withdrawn, but it costs like $2,000, $3,000. In some parts of the city, the CP Rail still has a right.
I was going to see CP Rail as an example. Yeah.
They have a couple of them. My favorite is out in Langdon, where they can put a gravel pit. We're taking out your house, we're putting in the gravel pit. I mean, they're never going to do it, but it's on title. They have a right to, and you have an obligation. Like if it's not supposed to be there, sellers are going to have to deal with that. And see people discharge it. The hardest part is finding the right person, and then you just pay them, and they'll take it off.
The Scholdice family having stuff
all
regarding
over.
what's you can put in your backyard, what you can keep. Obviously, restrictions from how far you can build in front of the street.
Yep.
Those are big ones, especially if you say, I want to do a front drive garage, or I want to do something else.
Or subdividing and putting 2 infills. You're only allowed one residential unit per. And
Yep.
So there's lots of restrictions. And people say, but the city said it's okay. That's nice. The city says it's the community. This is a community standard thing.
Yes.
The city will give you a letter that says, we do not take a stand on this, but they're still valid and still on there.
So Jeff, you see it on title, and then what should you do?
All right. So read it.
Sorry. Say,
Let's
say
start
it
again. Yeah.
So you see it
when
on
you see it on title, you're going to see it on there, and you're not just going to mention it to your city, your client. You're going to say, or you're going to read it.
Okay, I think I'm keeping up with you.
All right, perfect.
But,
yeah. So, and a lot of times they're intimidating. Like they're intimidating because there's a lot of legal blah, blah, blah.
Absolutely.
And I'm going to break it down into 3 categories. You got restrictive covenants that are super old. You have restrictive covenants that are, we'll call them normal. And then we've got we'll call them the super restrictive covenants that, they've registered them on an entire community, but there's a lot of schedules at the end, and so they only deal with, certain ones with certain houses. So we'll go through them right from the beginning.
Controls, things like that.
All kinds of things.
Yeah, okay.
Yeah. So the super old ones, I'm just going to say, they still count. It can be 1911. The people have been dead for almost 100 years, but they're still enforceable. So you still have to deal with them. And discharging them or changing them can be expensive. It's the service issue that's the big one. If you have just 2 properties, then serving those 2 people is easy as long as they're properly drafted. The court sometimes says it's not properly laid out who has which property, so you have to serve it on the whole community. Right. When we dealt with one in Oboya, we had to get a substitutional service order that then gave us how we have to serve people, because it's not practical to take a whole community and personally serve them. All right, you've been served. It's too costly, but it'll take a long time because they want 2 or 3 months of publishing in the community newsletter and stuff like that. And so it's time consuming, it can be expensive, and you don't know what your result's going to be. Sometimes it's easier to amend it. Okay, we're not going to have it deleted, the garage, there's still a restriction on where a garage can be, but we're going to make it 2 feet instead of 3 feet. That's sometimes easier. If a community takes a stand or an individual takes a stand and fights it, you could have a big problem. None of them are rubber stamp, like it's going to be easy, unless you have a limited number and everyone agrees on removing it. We're dealing with one in Canmore now. The whole community has basically said, we're going to get rid of this thing and it'll be okay. It should go smoothly.
Right.
Yeah. So should we take you through how to read it?
Well, let's just, just for the sake of just saying it, take them through how to pull it off of spin, because you have an instrument number. Yeah. Talk about that just for a second.
So on the left side of the title, there's going to be the instrument numbers. So show like the transfer, mortgage, utility right of way.
Yeah.
So that 9-digit,
I think so.
That long number, you're going to put that into spin and pull the actual document.
Perfect.
Yeah.
So in spin 2, you'll see like documents and registrations or titles and whatever, and you put the instrument number in, and it'll come up, and you can download it and purchase it.
And Lindsay will email you the step-by-step guide on how to download it.
Of course, absolutely.
We'll make a graphic video about that.
But only once you've tried. Only once I've seen you personally try first.
3 times.
Yeah, 3 times. That's right.
So you're gonna pull the document and you're gonna actually look at it. And there's going to be a lot of legal blah 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 at the beginning. You can whereas, wherefore, blah blah blah. Ignore that because we don't care.
Yeah.
What we care is like the guts. In the middle is going to be the guts, and it might be something like you can't change the grading because the water, you want water to flow the way it's supposed to. Cochrane, they are very, very enforcing against any changes to grading. Fences, roofs, whatever. But there's going to be in the guts, and that would be the normal one. And even these super old ones, you can't have a house of ill repute. You can't have livestock, whatever.
Feathered animals and things like that.
Yeah. So whatever the restriction is, you can't do those things. And if you're not planning to have chickens and there's feathered animals, who cares? It doesn't matter. If you're not running a brothel, okay. So it's on the title, it's restrictive, that's okay. Just know your buyer has to know that they can't run a brothel out of that home.
Yes.
And with the number of massage places that are all over the city with hours that start at 2 in the afternoon and go until 4 in the morning, I suspect that some homes are being used for ill repute reasons.
Probably fair,
Anyway,
yes.
your buyer needs to know.
Yes.
On these multiple ones, those ones are a little bit trickier and much, much more intimidating, but you still have to read them. First of all, you're gonna look at the back. You're gonna start at the back, because there's gonna be schedule A, B, C, D, E, F, G, H, I, J, however many. And you're gonna look at your clients, the property they're looking at what their planned block lot is, and you're gonna match it up. And you're gonna look, oh, Schedule A applies to these properties. Oh, doesn't apply. Ignore it, it's fine. B, it's fine, ignore it, because it doesn't match up. C, oh, C matches up, our property is included in there. So then you go into the guts, and you're gonna find the one that refers to Schedule C. You can't have a wood fence, it has to be a chain link fence. Or, sometimes they'll say you have to have, if you're putting up a fence, it has to look like this, and they've got the exact design of what the fence has to look like, so the community standard is similar. But don't stop there, because there could be multiple.
Yeah.
So you've got to go through each of the schedules, and you're just literally just matching up. It's oh, match, not match, match, not match, and see which ones apply, and then let your client know, and it's all good and happy.
Perfect.
Mostly.
Perfect.
Yeah.
Yeah. What do you mean by mostly?
Well, sometimes they're not going to want the property.
Oh, yes, I see what you're saying. Yes, of course. Yeah.
And then on the converse side, as a seller, you need to go through the same process also.
Totally.
Because in 2016, when Area changed the contract, they changed these magic words. And the magic words was adding something to the effect of the seller will provide a real property report, stamp compliance, blah, 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 that is up to date. But the words they added in are, and reflect the representations and warranties made by the seller. So the seller says that nothing is in conflict with the restrictive covenant. Great. In the old days, before 2016, I'm old. In the old days, before 2016, June, July, whenever it was, if you had a real property report with compliance and you delivered it to the lawyer, they couldn't really do anything. There was no guts to be able to do anything to force a seller to rectify it. They could sue them for damages. They'd have to prove their damages. It'd take 2 years. 0 clients, when we pointed it out, actually wanted to spend the money to deal with it. It cost $12,000, $13,000, depending on where it goes. Now with the contract, if there is, so let's use the garage example and it's only things that have to show up on the real property report. So if there's a garage that's 2 feet instead of 3 feet away from the lane, then as a buyer's lawyer, it is treated as importantly as the actual transfer of land.
Wow.
Like ownership of the property. There's no distinguishing between the RPR being proper and the title. So what happens? Buyer can walk away. They can walk away, and we've seen damages awarded against sellers, it was about 10 grand, for failing to be able to provide the property with the real property report compliance. The buyer can say, I'm not paying you a penny, and you shall, because it says in the contract, shall give me possession of this property until I get a real property report compliance. We could be talking months, and the only thing that the buyer is going to pay is what they would have paid under the mortgage, interest rate at mortgage rate, mortgage amount. Seller still has to carry their mortgage, insurance, so there's a lot of consequences. A buyer can say, look, I'm living at my parents' house. I don't need possession on this day. We're going to wait until you get it. We're not giving you a penny. They've got to maintain an empty house for sometimes months until the restrictive covenant issue is dealt with. Or we can negotiate a holdback that will be situational. It's not a contract-driven thing. The contract doesn't say, oh, you can do a holdback. But the alternative is, well, if you don't agree to a holdback, then we're just not going to close. So it's in a seller's best interest. Okay, let's figure out a number that works.
Totally.
We can usually come up with that number if we have an idea of what the problem is. If we have 0 RPR, it's hard to pick a number, but process-wise, those are our choices.
So obviously, sellers and buyers both matter.
100%. Yeah, before we put the listing on. Let's get on it right away. And we've been saying this for years, probably since the invention of the RPR in 86, 87, whatever they started.
Yeah.
But you really should get your client's RPR right away, included in your
supplementary documents.
Feature sheets, like the stuff that's sitting on the counter and stuff. And we've seen agents save their backsides because the location of fences and whatnot, where the buyer says, I want 50 grand off this price because the fence is over here, but the property line is way over here and you didn't disclose it. Well, actually, it was in the feature sheet. Your client made reference to it in emails, so we know you actually saw it. your realtor should have pointed out to you on the other side of the file. For our client, it went away. The agent representing the buyer didn't have such a good experience with their client and their lawyer. So
And I write many contracts subject to review the RPR. If there's something that's...
you have to be cautious with that, though.
Well, I appreciate that, but we found, actually this is a good Chloe story. We bought a house in Cochrane, and it had an addition that I didn't know if it was compliant or not, and Chloe had the RPR. So we had a 24-hour condition, and it was done. And I reviewed it, looked good, and that was it. Tell me about the
So the only caveat,
yes,
legal word, for warning, it's Latin for warning. So the only issue is, if there's a problem, you can't just waive the condition. No different than, if you're subject to home inspection, and like, oh, the roof is like not even 3 months left, it was gone 2 years ago. Your client's not going to want to just, oh, okay, we'll waive the condition, and then we'll just assume everything happens right. You got to then write in something that
Yes.
make sure that the terms and conditions still apply in the RPR.
Totally fair.
Or in the contract. Yeah.
Awesome. Jeff, thank you so much.
Thank you.
Yeah, outstanding. So much knowledge. Heed the warning. Read the restrictive covenants.
And call if you have questions. Perfect. Like, call me, Lindsay, call me.
Call
me.
On our
It's not a
Quick Connect.
problem. Or email.
You guys can
Quick
contact
Connect.
contact Kahane Law.
If you have my
on
cell,
Quick
just
Connect.
call my cell. You should have it.
Yeah.
Should I just give it quick?
Yeah, if you want. Absolutely.
Wow. that's cool.
403, write that down. 403, it's Calgary. I hear giggles. 561-8423. Save it in your phone. If you have a quick question like that, like, Jeff, we're not really sure about that, just call, and then we can work it through, because it's so much easier. And I'll never ask, is it our client or not our client? If most of them are fairly quick to go through, like, let's just make everything smoother for everybody.
Thanks,
Outstanding.
Jeff.
Jeff,
That's
your
awesome.
service is outstanding, so thank you for that.
Thanks for having me.
You're welcome.
We're gonna, if we save just one client a nightmare today,
I like it.
we've done
And
our
it
job.
makes Halloween just that little bit less scary.
Not in my house.
Not in your house. All right, guys. Thank you so much. We'll be right back.